Welcome to Behind the Law with the Ameli Law Group.
Welcome to Behind the Law with the Ameli Law Group with Chantelle Ameli and Mark Ameli of the Ameli Law Group in Los Angeles. They handle complex personal injury, business, and contract cases, and they prepare every case like it's going to trial. I'm Chelsea, and today we're talking about what most injury lawyers get wrong about your case. Welcome. And Mark, since this is our first time meeting you, would you like to tell our audience how your law group came to be?
Yes, our law group actually came to be in 1980 when I became a lawyer. That's now 46 years ago. And I was the first Iranian-American to become a lawyer and practice personal injury and workers' comp at the time. And later on, I started practicing business. And I went on until Chantelle decided finally to go to law school. And I say finally because initially she resisted going to law school. And the story of how she decided to go to law school is a long story, so I'm not going to go into it. But about 12 years ago, Chantelle passed the bar and joined the law firm. And since then, we've been working together, and we have had a successful relationship. And although we do fight every once in a while, but this time the fight is about the cases and
Not my
which way we
curfew.
should go, and not her hair, no.
So, diving back to the topic, can you walk us through what you usually see happening behind the scenes when a case gets pushed towards a quick settlement?
Well, the question is really whether who's pushing the case towards the settlement. Is it the defense that's pushing it towards the settlement, or is it the plaintiff? On the side of plaintiff, there are usually two reasons why a case may want to go to settlement, may want to be pushed towards a quick settlement. One is that the client is asking to get the case settled. And once the client asks, it's the job of the attorney to communicate with the client as to what the effect of going forward could be. And what is the effect of waiting a little bit and trying to develop the case before you settle the case?
One of the things that we were talking about earlier is that there are sometimes when a client will come in and will be expecting money right away. And something that we will always explain is that this sort of arena is not anything that moves fast. If you are looking for money to pay your rent this month, a lawsuit is not the way to make that happen. So a lot of times clients are in need of money, and that quick money is not going to come from a case or a lawsuit. So I think that's one of the things that just needs to be explained and is not always explained, meaning like the process of pre-litigation and the whole litigation process, it's very long and timely.
And the reason for that is usually because the attorneys just don't have time because of their revolving door offices. They have a lot of cases. They advertise that they're the largest lawyer corporation in town, in the city, in the state, in the world, and those other cases have to go through also, and so they don't have sufficient time to do that. And the other reason is that the attorney wants to push it through to a quick settlement. And again, that's because of that fact that they have to get these cases through the ringer so that they get to the bottom of the case and they get some money and be done with that particular case.
And then there's the other side too. Sometimes it's the defense that's trying to push and settle a case. And when that usually happens, it starts with the insurance adjusters. Almost every insurance adjuster will offer money up front before having any of the details of the damages of a case, some sort of $1,000 to $5,000 amount for the settlement of the matter. That is just simply throwing money at something to try to make it go away. It's less costly than having to actually deal with the issue itself. So sometimes they'll try to push money at you to just get this thing to go away. Another reason could be that they know that the value of the case is much higher. So they'll try to throw some money at this client just to see if they'll bite, settle it, and move on before the whole list of damages actually comes into play.
Or the attorney. Or
Right.
the attorney will move on with the case.
So, what tends to get missed early on when a lawyer isn't preparing a case to go to trial?
So if, for example, like just like what we were talking about, if an attorney is agreeing to those numbers, those initial numbers, what they're going to miss is the development of the case, which is going to include injuries, what they actually are, how much they cost, what future damage is going to be there, what permanent potentially injury is going to be there. There are also so many other factors that come into play as far as damages are concerned. Sometimes there is property damage, your vehicle, your clothing, your computers, depending on what sort of incident it is. There's also your loss of earning capacity. So these are all things that need to be developed so that you're certain that the value of the case is really what you're going to achieve rather than just whatever initial money the insurance company or other attorney is going to throw at you.
I have had so many cases that have come to me from other attorneys, and the clients tell me that they have offered me this much. What do you think? And I've told them, go and ask your lawyer. I haven't seen the case. I don't know the value of the case. You have to talk to your lawyer. They tell me, I trust you, but I said, you have to trust your lawyer. But, and I can't tell you without taking a look at your case and see where you are. There was one case a long time ago that I remember. It was actually a workers' compensation case that they had offered something like $15,000 to the client. And $15,000 at that time for a workers' compensation case was a decent number. He came to me and I realized that they have missed one major part of the case altogether. In that particular situation, he had a psychological injury that they hadn't even addressed. So when I got into the case, I amended the application, included the psychological injury, and after about 2 years, we were able to settle the case for something in the range of $95,000, which is quite a difference from what they had offered. Now, I must add that psychological injuries today don't have that value because the law has changed between that time and now. So people who have stress injuries at work, I don't want them to believe that their value of their case is high. It actually is not high. And we usually don't accept psychological injury cases in workers' compensation. But that was a missed part of the case that was so important and added so much value to the case.
So, this is a side question, just out of curiosity. If you're like, I need my rent money today, I'm going to take that 15,000 and settle right away. That person still wouldn't have seen that money very quickly. So you might as well develop the case and see what happens and work with a lawyer willing to do it.
Well, that's obviously, the client is the boss, and so that's their decision. And if they wish to do so, they can. But then remember, they missed on another $80,000 that came later.
And after the case is even settled, we still have to push paper around for weeks before we actually have any dollars and cents in our bank for them. So nothing, even the settlement is not a fast thing. Not one single part of this thing moves quickly. I mean, we try to push it along as quickly as possible, but it's never fast. Ever.
Good. That's good. That's good to know. That's good to set that expectation. How does an insurance company's behavior change when they know that the lawyer on the other side is actually willing to go to court?
You know, when I first became a lawyer, I obviously did not have the experience that I have now. And it was, I became a partner with another lawyer who had experience. And 4 months into my practice, he sent me to trial. And I did a trial. It was a bench trial, which means that it was a trial before a judge, not a jury trial. And it was successful. So later on, I continued with going to trial and trying cases. And there was a case that was a major case that came to me, and I wanted them to put in the policy limits, and they would not. So we went to a settlement conference before a judge, and the judge told me that, look, they're making this offer, and these guys know what they're doing. And I told the judge, I may be a novice, but I may go to trial being a novice. And they put the policy limits on the table, and I got it because they knew that if they don't, there's a possibility of losing. Since then, they know that insurance companies now know that I'm not afraid of going to trial, and I will go to trial, and I win. And if I go to trial and I win, their damages are going to be a lot more than what they can do at the settlement with much less expense. And so that does affect the behavior of the defense bar and the defense lawyers, defense adjusters. There has been so many times that they have seen me on the plaintiff side, and they say that, Mark, I know that you will do what's right for the case. And so we'll try to do what's right for the case also, which are usually too low. But anyway, we will negotiate to a better settlement. And they do settle easier with people who have gone to trial and who have a trial experience.
I think trying cases is the fun part. My background is in entertainment. So for me, anytime I can stand in front of a judge, it's showtime. And that is something that I miss from not performing anymore. So I have a lot of excitement about going to any hearing, let alone a trial in front of a jury. Like, here we go. But trials are very expensive. And so there are a lot of other tools that we can try to use before we actually have to end up in a trial. And we are always willing to mediate or go to a settlement conference or try to work it out if it's possible. But sometimes it's just not possible. So here we go. And we just move it along to trial.
You touched on this a little bit before, but what happens when the full impact of an injury isn't yet understood, but the case is already moving towards a resolution?
That becomes sort of troublesome. There are cases that have come to us in the middle. So maybe the prior attorney had already done some settlement talks. The prior attorney had already gotten some offers and was considering settling. And then the client will tell us they don't want that amount. They don't want to settle for that amount, and bring their case to us. And we review and see all of the things that are missing in there. So we will usually take some time and figure out what is actually missing. What can we fill in at this now seemingly later date? When we can go through everything and develop it, then we will move forward with a settlement. I never feel comfortable just grabbing money and moving on. I really believe in my clients and I really believe in the cases that we take. So I don't like to just wishy-washy take something and just throw it at people and hope that they're okay with it. So typically, we will take the time to make that happen because there's a lot of money potentially on the table that we're leaving behind.
Of course, we said, the client is the boss. And if the client wants to take a smaller amount of money today rather than wait for another year to go to trial, that's his or her prerogative. But sometimes also clients really ruin their cases. And there was a major case, again, that I went to trial, and that I lost that case. It was because my client, by the way, let me tell you something that a judge once told me. I was negotiating a case with the defense attorney, and I told the judge that I have never lost the case. And he said, well, you haven't tried enough cases. And that's so true that, with people who advertise that we have 99.9% winning, they either are not getting the value of the case, and that's why they're settling easier, or they haven't tried enough cases. But in this particular case, we went to trial, and my client brought up a subject that had a value of about $4,000. He said that I had lost $4,000 in school because I couldn't go to school. And that caused the defense attorney to bring in the chair of the department, his professor, and everybody else to show that this guy was flunking out anyway. So he did not lose any time because of the case. That caused the jury not to believe anything else that he had said during the trial. And I interviewed the jurors afterwards, and that's what they told me. And it's so clients have to pay attention to what their lawyers are talking about, what their lawyers are telling them, and apply those. I had told this gentleman that that's only $4,000. Your case is worth probably $500,000 to $1 million. So don't go for the $4,000. Forget about that. And he decided that that $4,000 was important.
Yeah, the relationship between you, your client, and your attorney is very important. It's 100% trust. We are basically standing in front of our clients and speaking on their behalf. So if you don't trust that what your attorney is going to say is the right thing, then that is not the right fit and you should have probably a different attorney. These sorts of things happen a lot because every client, it's very personal, the things that have happened that have caused their lives to change because of whatever incident or accident. Those things are very personal and every detail about it is very important. But for the people that are looking from the outside in, that's where our perspective comes into play. While we want to make sure that our clients are being taken care of and all of the things that they have lost, they're hopefully going to get back as much as possible, there is also what other people from the outside are going to find important and worthy. And when you're going to a jury, that's who you're asking. These 12 random people, this is what happened to me. Don't you guys think that this is what I deserve? So when you're petty, they see that. When you're trying to fight about $4,000, but meanwhile you're asking for $1 million, that seems petty. You become unlikable and jurors will not care and will not want to help with your recovery.
So many good nuggets for the first episode. Thank you both so much. That wraps up the first episode of Behind the Law with the Ameli Law Group with Chantelle and Mark of the Ameli Law Group here in Los Angeles. If you're dealing with a serious legal issue and want a team that prepares every case with a trial mindset, you can learn more at ameligroup.com. And if you found this helpful, be sure to subscribe, leave a review, and share the show. Thanks so much.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.